All right, everyone, please be seated.
Welcome everyone to the 2022 Blakely-Butler Moot Finals. Congratulations to all our finalists for making it to this last round. We have for Team 4, the Petitioner. Speaker 1 will be Materne. Speaker 2 will be Mahsa, Monshizadegan. For Respondent, we have Team 9. Speaker 1 will be Geoffrey, Okolo. Speaker 2 will be Deborah, Gillis. For our esteemed panelists of judges today, we have Chief Justice Jewell, Justice Farris, Justice Meg Poissant, and Justice Yvonne. Good luck, everybody, and congratulations on making it.
The case before the court is Blue Farming Inc. versus Newport. The petitioner and respondents are each allocated 24 minutes to present their case.
Your Honors, may I first please do. How much time would you like to save for rebuttal?
Your Honors, I would like to reserve 2 minutes for rebuttal. Chief Justice, Your Honors, may it please the court, my name is Materne, and I'll be addressing the issue of whether the state of Newport failed to state a claim for public nuisance for the reasons set forth in the lower courts by the lower courts in this case. And after that, my co-counsel, Ms. Monshizadegan, will address the issue of justiciability under the political question doctrine. This case is about ensuring that products liability cases are addressed through the right mechanisms and ensuring that this court upholds the practice of sending political questions about regulatory sufficiency back to the political branches. Prior to this hearing, the case was originally resolved by the trial court as a 12B6 motion in favor of the petitioner and then reversed by the 15th Circuit Court of Appeals. And we ask that this court reverse the 15th Circuit Court of Appeals and uphold the trial court's judgment, because I will show that the respondent did not state a claim, that there is no public right implicated by the claims the respondent brought forward, and show that abatement is impossible. The standard for stating a claim was established in Twombly and reiterated in Ashcroft and requires the complaint must contain a short and plain statement of the claim, and it must show that the complainant is entitled to relief plausibly on its face. The trial court correctly objected that the respondents crafted a very convoluted right to some sort of public interest, some sort of public right, and it took a very circuitous logic by the appeals court to find this public right. The appeals court looked at claims that the state's people were living in fear of addicts and were negatively affected by costs expended in paying doctors, paying law enforcement to combat this epidemic. And then that appeals court took that and somehow arrived at this being a claim that our clients have interfered with the public right to access hospitals. This is not.
May I interrupt for a moment? What do you make of the West Virginia case, Extra Morrissey, and how does that impact your argument here today?
Excuse me, Your Honor, I'm not quite sure what that case is referring to.
All right, go ahead.
Again, all of these nefarious actions that the respondents have claimed Blues have engaged in are not relevant when you realize there's no public nuisance right that they're actually attaching the claim to. And
What can I ask you a question about that? What exactly are the acts?
the act that have been alleged are that Bluth has somehow mischaracterized their the addiction potential of their products through I believe that the respondents claim that we have engaged in unbranded sponsored research or downplayed the addiction potential of drugs to prescribers.
Isn't the Iqbal standard a relative?
Yes, Your Honor. It is a very relatively low standard for the facts that are being pled. However, the claim that has not been stated here is that of a public nuisance. While they can allege the facts that they believe indicate some sort of products liability claim, what in this case, they are trying to attach those factual allegations to a public nuisance claim, which I'll demonstrate is not appropriate.
Well, why isn't public health a right that's common to the public?
So as established in Camden County Board of Chosen Freeholders and the state-led industries cases, public rights are rights that are available to everyone. They may, and not just a right that everyone has, but a right that is common to the public as an entity. Usually these rights are considered rights to things like parks, open commons, rivers, other types of infrastructure, or actual physical property. The state is trying to push this into an unreasonable standard of them having a right to abuse-proof products, them having a right to access hospitals and not have money being spent on police where it should be being spent on something else, which is not a cognizable right similar to the right to access a park.
Counselor, is it your argument that public then does not have a right to police protection, to hospital care?
It is not, Your Honor. Our position is that while the public may have those rights, those are actually rights to individuals. And even if they were rights to the public, they're too tenuous to attach any public nuisance to, because we have no case law at this point that has this idea of the public health in general as some sort of commons in and of itself that the public has the right to access. To be able to interfere with the right to access a public right, there has to be some mechanism for accessing it. There's nothing here that the respondents are claiming our company's actions are directly interfering. So I want to talk about that a little bit, because in Camden County Board of Chosen Freeholders and in the lead industries case, we see both of these courts articulating a attenuated chain of events that they can specifically point to and say producers of these legal products should not be held liable to third-party bad actors. This is a very simple concept. If an intervening criminal action occurs, you can't bring liability up the chain, this attenuated chain, all the way to the producers.
Isn't that in question of proximate cause? I thought that was not an issue here.
That question is not an issue as an element of the fourth element of what constitutes a public nuisance. However, the third element of what constitutes a public nuisance is whether something is within the defendant's control and capability to abate. And as I'll show, this idea of the attenuated chain of control is directly linked to whether whether Blue can abate any of the actions, can affect the result that the state wishes to affect. These cases that we have on this attenuated chain of connections say, especially in lead industries, say the responsibility for a nuisance lies with the party which can abate the conduct which is causing the nuisance. However, Blue has complied with all federal regulations and it cannot improve upon that activity.
It just stop manufacturing the drug and with that solve the problem.
It wouldn't solve the, as my colleague Monshizadegan will address, there is a valid use case for these medications. That valid use case was addressed by the FDA and the DEA, despite our company within the regulations notifying the DEA that there was abuse potential. Just because a drug can be abused does not mean it doesn't offer a public benefit. It offers a public benefit to many people who need a heightened level of pain mitigation. And as I was referring to, the Blue cannot produce this drug in any other way than it is doing right now. It has an authorization from the FDA, and it must produce it in coordination with that authorization. Changing the medicine would offer no relief, and it would not address the public need of these medicines. And there have been no allegations that Blue is directly hemorrhaging these drugs into the society at large and causing this profusion of addiction-causing drugs. All the state is claiming is that we have put a drug into the market that can cause addiction, and that people who have become addicted after being prescribed these drugs or themselves paying them illegally have become a burden. However, what the actions that Blue is engaged in, none of them could be sufficiently changed to abate this issue. This only leaves the marketing practices, which the respondents will harp on very heavily, that one part of their abatement strategy is that we should stop this marketing effort. However, marketing efforts are important to get these drugs in front of doctors so that the doctors know what is available to them. And the petitioner is completely capable of ceasing all marketing efforts. But again, the state does not claim that our marketing efforts have directly put any pills in citizens' hands. The intervening criminal actors are every doctor that has overprescribed these pills. They're the targeted burglar, the people committing targeted burglaries to find these pills and move them into the black market. They're street drug knockoffs, and they're patients who are engaged in malfeasance. All of these things are criminal actions, intervening criminal actions, breaking chain of liability. And for this reason, you should uphold the trial court and reverse the appeals court. Thank you, Your Honors.
Thank you, counsel.
May I approach the podium now?
May it please the court. As my co-counsel has stated, my name is Mahsa Monshizadegan, and I will be addressing the second issue. The first issue demonstrating what the state's claim raise a non-justiciable political question. This court should reverse the 15th Circuit Court and hold that the respondent's claim is barred because public nuisance question inherently implicates political question doctrine. I'll address two issues as follows. Non-justiciability, a question, issue, case, or controversy is non-justiciable when it is not constitutionally capable of being judicially decided. The courts may take many factors into consideration when it comes to political question, but today we will address the first three factors of Baker v. Carr 1962 because the trial court considered the second and third factor, and the 15th Circuit Court considered the first two factors to be applicable. Addressing the second issue, which states a lack of judicially discoverable and manageable standards for resolving an issue. The trial court stated on page 7 of the record that a federal district court in California dismissed a municipal public nuisance claim brought by a village in Alaska against oil and power utility companies for their alleged production of greenhouse gas emissions that cause global warming, citing to native village of Kivalina v. ExxonMobil Corp. 2009. The court found that the public nuisance claim was beyond the scope of judicial expertise and applied the second and third Baker factors because the claim in that case required the court to make initial important judicial determination.
Counsel, what do you make of the intermediate court's holding here that Baker Factor 3 may not still be good law?
I'm sorry, Your Honor, can you repeat your question?
What do you make of the argument that Baker Factor 3 is really no longer in play anymore?
Well, yes, on that, for that case, actually, we believe that the 50, yes, the 15th Circuit Court said that after Zivotofsky v. Clinton, there is a serious doubt that the Supreme Court would consider all 6 factors in Becker case and would probably mostly consider the first 2 Becker factors. But this is like stating that Becker was already overruled, which Becker is still a good law. So we cannot say that only the first 2 Becker factors apply, as it's arguable that which factors would like determinately apply to a political question case. However, also in Zivotofsky v. Clinton, it was a matter of a statute and whether it may be given an effect or instead be struck down in light of authority conferred on the executive by the Congress. But here, there is no statute involved. This is
Wait, I thought that there was in fact a statute that specifies what the definition of nuisance is. So are we squarely under the umbrella of Zivotofsky?
Your Honor, in this case, as we are addressing the political question, the presumption of the state is that there is, I'll point that again. So it's a matter of the state, presumption of the state that this particular drug caused the opioid addiction, but technically there are federal agencies that have already approved this medication.
But we have a state statute, right? This is a state law claim, isn't it?
Yes, Your Honor.
And we have I'm looking at the statute right now that specifies the definition of nuisance.
Yes, Your Honor, but it's still based on Zivotofsky that the 15th Court stated that only the first 2 factors must apply. That's not the case because the Becker still is a good law. So all 6 factors may still apply.
Well, I just think that, how do you address the fact that if the legislature of Newport has already specified this is what a nuisance claim is, isn't it up for the courts to apply that law to a specific set of facts? Isn't that all that the state is doing here, asking us to do here?
No, Your Honor, I would say because the drug has been already regulated by an expertise administrative agency, which has been assigned to do what has been done here, which is regulating this drug through FDA and the DEA, because this drug was considered to be a narcotic drug. So it went through the DEA process, which regulated also the retailers, the sellers, the distributors. So the Blues Pharma, our client here, has already complied with all the rules and regulation that was set up for them to go through before this drug gets to the market.
But can a court just analyze that in the context of determining whether there was an unreasonable interference in the public right? So to adjudicate the nuisance claim as it would any other.
Your Honor, I would say no, because then you would need an initial policy determination. What the standard are we considering to basically judge this drug on the benefits and risks of using this, and like what agencies and what political departments are coming into this court, because they have this, FDA has already decided and approved this drug. DEA has ran all over the place with the distributors, with the sellers, and made sure that the drug is complying with the rules and regulation. And then once it comes to the court has decided, okay, did the FDA make the right choice and regulation? Do they have any issues? Are they just making these points up just to approve any drug and send it to the market? So there is no standard that the court can use to make that decision unless they are, coming up with brand new standards that does not exist or there's no precedent for it.
Counsel, what is your best case supporting your position that this issue is not justiciable?
It's not just, Your Honor, I would cite to the city of Milwaukee, the Illinois and Michigan 1981 Supreme Court. In that case, the issue was the polluting of the Lake of Michigan because of the overflow of the untreated sewage from the sewer system, and it was concluded that the Congress has not left a formulation of appropriate federal standards to the court through the application of often vague and indeterminate nuisance concept and maxims of equity jurisprudence. but rather has occupied the field through the establishment of comprehensive regulatory program supervised by an expert administrative agencies. And in this case, the opioid drug has gone through the administrative agencies, which is the FDA and the EDA, and has gotten approval from that, because it was believed these agencies have been put in place so that these kind of cases don't come to the court, because they have already gone through the regulation. So if there was an issue with this opioid drug, that would, of course, we are not saying absolutely there is no risk with the drug, but the main point is that it has gone through the regulation. They have not done anything wrong, and they have not jumped over the fence and surpassing one law because they wanted to get this drug to the market. The administrative agencies were there, they went through it, they got approval, and the drug came into the hand of other experts as doctors and other licensors in the state to be able to prescribe these medications to people who actually need it, who are in pain from chronic pain due to other different reasons. This is not to be prescribed to people who have mild headache or some stomach ache. This is for people who are actually in pain and in need of such drug to be able to live their life day by day.
Well, why isn't this a case like so many others where nuisance law can fill the regulatory gaps? Because we all recognize that there is regulation here, but that regulation still has left gaps that have resulted in this massive public health crisis. So why can't nuisance law step in and kind of fill those gaps to sort of promote the general welfare, so to speak?
Your Honor, I cannot agree to say that the regulation has left a lot of gap. It's just because to what extent can we control the society? This drug is getting into the hands of pharmacies, doctors who have spent years studying, getting licensed, gaining experience to prescribe this to people who need it. But of course, in a society, there are always people who will misuse a good thing that's in the market, because people who are probably, I would say, drug addicts who come to the knowledge of this drug, it gets to the black market, it gets into the criminal's hand, and it gets distributed into the market. So how can a company like Blue Pharma control the whole society? Even if this gets to the court, the thing is it has to pass so many standards, because it's not one or two issues that creates the drug addiction. It's multiple issues in the society, and different societies could be being poor, needing money, or overall not, being in a growing up in a bad neighborhood that caused you to act in that way.
Aren't there allegations, though, that Blue made misrepresentations to physicians and other members of the public to downplay the addictive propensities?
Your Honor, that's what the respondent is claiming, but there's no proof to it, because...
Well, aren't we at the pleading stage? We have to take those allegations as true.
Yes, Your Honor. So the Blue Pharma has advertised, but we have advertised based on our regulation. Your Honor, my time has come to an end, but if you allow me, I'll answer your question.
Yeah, why don't you take another minute?
Yes. So the Blue Pharma have passed through the regulation and then done the advertising based on the regulation that was set for it. It has not claimed anything more or less. So they have approved to say that this can cause addiction, and that's what has gone to the market. But now they cannot be claiming that, okay, we have been approved for addiction, but now we're going to advertise that we are super addictive. So whatever they have been approved of, that's what they have claimed on their marketing and advertising. However, the respondent wants to believe that we have done more than that. But I'm going to conclude, as my time has come to an end. For the reason I stated above, the petitioner respectfully asks the court to reverse the 15-second and find that the state's claim is non-justiciable political question. Thank you, Your Honor.
Thanks, counsel. Counsel for respondents, whenever you're ready. May I first podium, please?
May it please the court. My name is Geoffrey Okolo, and I, along with my co-counsel, Deborah, Gillis, Harry, all represent the state of Newport, who are the respondents in this suit. I will be addressing the issue of non-justiciability, and my co-counsel will demonstrate that the public nuisance claims are sufficient. This case is about ensuring that when applicable, the court remains an avenue for relief. So this court should affirm the decision of the 15th Circuit Court and find that this issue is justiciable because the Baker factors are inapplicable.
Can you tell me what your best case is to support your claim that the claim is justiciable?
We claim that the Baker factors, it doesn't satisfy any of the Baker factors because the courts would not be infringing on rights that have been exclusively delegated to political branches of government.
What's your best case that says that?
The best case that says that, I would say that would be, I think the Connecticut versus American Electric Company case is very, very comparable. There, some states sued, what's it called, energy manufacturers, some people who make energy for pollution claims. And under public nuisance, they were able to get relief through that avenue.
Could I ask just a follow-up to that? Why isn't this case like Native Village? As I understand that case, the court said that it would have to weigh the utility of alternative sources of energy and the reliability against the sources that were at issue there. And here, don't we have the same situation where we would have to consider like the effectiveness of other pain medications, as well as like potential for people to turn to illegal substances like fentanyl if they can't get the pain relief that they need? I mean, isn't this just the type of issue that is typically reserved for political branches to kind of weigh these competing considerations?
No, Your Honor, this case is very, very different because at the heart of the dispute is the marketing practices that have been adopted by Blue and the other people who are petitioners of this suit. Also, our claims are specific. It's specific to those group of people who market as well as manufacture drugs for the city of Newport or the state of Newport. I will flush these out as I do my analysis on factor 3 and factor 2. The dispute today does not turn on standards to apply judicial application. Echoing the court's sentiments in Comer versus Murphy Oil, common law tort claims are rarely thought to present non-justiciable political questions because they provide clear and well-settled rules the court can easily rely on to resolve the dispute. In the case before us, the state is not asking the courts to engage in policymaking to address the opioid epidemic. Rather, the state seeks to determine whether the drug manufacturer's conduct entitles the state to relief under the common law. In response or referencing your discussion about which standard we should use when evaluating the Baker test, we'll concede all 3 factors of the Baker test, or the first 3 factors are available in this, but we would argue that none of them are applicable. Also, we'd like the court to adopt the standards that were used in Comer versus the Comer case, which says that the standards are ranked in importance as well as specificity, or in importance as well as how critical you should look at them. So the second standard, very, very important. The third standard, I think, requires a higher burden. First, I will explain why the respondent is entitled to relief under common law. Then I will lay out the standard the court should adopt to address this ordinary tort suit. On to factor 3. The FDA silence on marketing standards creates a regulatory gap that can be filled by the court without an initial policy determination. Therefore, the third factor is not met. The court reasoned in Illinois versus City of Milwaukee that statutes may be a sort of federal common law, but they will not necessarily form the outer limits of such law, unless when preempted by federal law, or if the courts creates a standard that is in conflict with regulatory agencies. Common law nuisance doctrine can fill in regulatory gaps and provide a remedy for the affected parties. The FDA is the source of regulatory law, providing guidelines for drugs approval, its efficacy, as well as labeling standards. But the FDA is silent on the marketing practices we seek to abate. These include funding third parties to assert false claims. The FDA does not regulate the claims of third parties. Casting doubt on the FDA's assessment of the risk of non-opioid drugs. The FDA does not regulate claims about other drugs. Mischaracterizing symptoms of addiction as pseudo-addiction. FDA does not regulate the characterization of adverse symptoms. Whether you want to call it pseudo-addiction or addiction, it's still going to be a Schedule I drug. This means that much like Connecticut versus American Electric Power Company, the numerous common law nuisance claims that precedes it, the court does not need to wait for an initial policy decision to make an initial policy determination. Therefore, the third Baker standard is irrelevant in this case. On to the second factor. Baker's second factor is not applicable. The dispute is not about drug use and the policy implications that may stem from that. It's about marketing. While this distinction narrows the standard provided by the tort of public nuisance when balancing the utility of how petitioners characterize their drug when marketing it with the harm it caused to the state. This gets to the heart of the utility question. Rather than saying, oh, what is the utility and benefit of these opioids versus the harm they cause, it's what's the utility and benefit of Blue's marketing practices and weigh that against the harm they cause. And we will argue that we can provide information that a fact finder can use to determine whether Blue's actions were reasonable. This case specifics might be complex, but as the court said in Connecticut versus American Electric Power Company, tort common law and their statements, though broad, provide a workable standard that the court can rely on to tackle complex problems. Our theory of the case plays out like this. If the doctor is a filter, Blue's marketing practices aim to wear down that filter so prescription drugs can flood the market. They do this by characterizing symptoms of addiction as pseudo-addiction, and this can all be seen on the record, page 3 and 4. By characterizing symptoms of addiction as pseudo-addiction, by casting doubt on FDA assessments on non-opioid drugs, by most telling, funding front groups to distribute false characterization in educational spaces, in medical journals, and in similar venues. So when doctors in Newport are going to go get the most recent education or recent information about medical practice in journals or continuing education seminars, or new aspiring doctors are going in classrooms trying to learn, like, when is it appropriate to prescribe an opioid drug? They're being taught this by the front groups as well as these third parties who are funded by Petitioner.
Well, could I interrupt you on that? So we do have another kind of tool at our disposal. There's a field of law called products liability, and it usually, addresses, the claims that are made about a particular product or a drug. How are we able to decide this under nuisance? Like, if we do this under nuisance, aren't we just essentially swallowing all of products liability here?
Well, Your Honor, we would argue that products liability would not be the right avenue for seeking relief because there's no causal link. The doctors aren't the people who are creating the product, it's Petitioner. So public nuisance is the most appropriate avenue to seek remedy. Also, the factors such as characterizing the symptoms of addiction and pseudo-addiction, casting doubt on FDA's assessments, as well as distributing false information in educational spaces, are concrete factors to measure the force of Petitioner's conduct and to determine reasonability. Furthermore, the cost of the campaigns, the revenue from the campaigns, or the revenue from the sales, I should say, and the accuracy of the drug representation by Blue's representatives are quantifiable factors that can be evaluated by a fact finder. As a foreseeable result of this 20-year endeavor, it is no surprise that Newport's doctors liberally prescribe opioids. Bluth's funded journals and teachers in educational spaces taught them to do that. It is clear that Bluth's marketing aims to sabotage the judgment of Newport's medical community. This has caused drugs to flood Newport and interfere with public rights. The relief we ask for is abatement on marketing practices, abatement on the production of the drugs because we are in a state of emergency, and relief for damages. Damages can be discoverable, or how we calculate damages can be done in discovery. They did do targeted ads, so we can get like the list of targeted ads. We can know what journals they published their false information in. We can know what seminars they sat in. That's all discoverable, and we can get the pool of potentially affected doctors. We can get their prescription logs, and we can cross-apply that to hospitals. We cross-apply that to police stations. We cross-apply that to debt, so we can get a more specific number for damages. This approach is management. It is discoverable, and we can use to get a reason and specific number for damages. This is why our case is different from the native case. We are very, very specific, and we are using the court as an avenue for relief for the injured party because there is a regulatory gap here. Even after abatement, undoing the effect of a 20-year campaign will take time, but the faster the misinformation ends, the faster we can begin to the road of recovery. Pretty much the Baker factor, or the second Baker factor, is not applicable here. This is not a political question, it's justiciable. We can rely on the standards that have been laid out by public or common law to reach a reasoned decision. And for these reasons, I believe that this court should affirm the decision of the 15th Circuit Court. I will use the rest of my time to respond to some of the stuff directly that was said by opposing counsel. They claim abatement is impossible. I've already laid out how abatement would work and the relief it would cause. They claim that Bluth is compliant with regulatory, Bluth is compliant with the FDA. We claim that the FDA is silent on these issues. And so compliance is not really at the heart of this dispute. They claim that intervening criminal actors, I will just reiterate that this court should affirm the decision of the 15th Circuit Court. Thank you for your time.
Thank you, Counsel. Please.
May it please the court. As my co-counsel stated, my name is Deborah Gillis here, and I will be addressing the second issue, which is whether or not the state failed to make a plausible claim for nuisance, for public nuisance. We believe that we have made a plausible claim for nuisance under the Iqbal standard. Before I move into my major points, I'd like to reference some of the things our opposing counsel brought up in their argument. The first issue is that they want a motion to dismiss, but we believe that this is unwarranted. The Iqbal standards provides that as long as you bring tangible facts and you make a plausible claim, you're entitled to satisfy the Rule 8A plausible claim standard. In our situation, we are looking at public nuisance. Under the Seward City v. Blaine, which can be found on page 10 of the record, in order for an activity in question, this particular case, the conduct in question must substantially interfere with the right held common to the public. Secondly, there must be an unreasonable interference of this public right. And thirdly, it must be within the defendant's control, and the defendants must be capable of abatement. We are not discussing the fourth issue because we have determined that we have disregarded the proximate cause for this argument. We believe that firstly, in order to address the issue with public right, I will draw your attention to page 10 of the Newport statutes, which I will read to you, that said, any conduct or activity that is injurious to health, indecent, offensive to senses, or an obstruction to the free use of property, so as to essentially interfere with the comfortable enjoyment of life or property, can be classified as public nuisance.
Well, if we take the conceptualization as like, as say, public health, the right to public health. I mean, wouldn't you be able to sue all alcohol manufacturers for nuisance, for the public health issue of alcoholism? Wouldn't you be able to sue all soda manufacturers, for public health, nuisance of say, tooth decay? I mean, wouldn't this essentially swallow everything under nuisance law?
Yes, thank you, Your Honor. That is a great point to focus on, but we do believe that regarding this particular statute, while we did not write the statute, we believe the statute is focused on intense injury. If you look in the beginning, it says any conduct that causes injury to health. So while alcohol or soda could be bad for your health, it is not as detrimental as the opioid drug that we have in question today. Going back to my first point regarding the public right issue, the petitioners tried to reduce public rights to something that only affects an individual, and in this particular case, addiction. The petitioners believe that addiction affects just an individual, but that is not correct. If we look at the resources that the state is spending in order to address this crisis, it will definitely show the trickling effect of the chain reaction from that one specific addiction. In particular, we have spent billions of dollars annually in addressing opioid crisis. We can argue that first, in order to address this issue, we are expending resources that go towards public safety, such as the police department. Our state hospitals are clouded. We have individuals who have perhaps other ailments that they're not being able to get a remedy for, because our state hospitals are addressing addictions or patients who are overdosed on opioid pills. That is causing a very large issue with the public health, and it is affecting the public. And beyond that, these individuals who are marketed for the opioid pills are individuals of very vulnerable population. These individuals include veterans who suffer chronic pain. These individuals include elderly people, people who heavily rely on these drugs, and they make a huge part of our society. If we have a young child that their parents, as opposing counsel mentioned, their parents might be struggling with addiction, it trickles down the effect of the kind of community that we have for our Newport citizens. And as a state, it is our job to ensure that every public interest is being addressed. So that's one issue regarding the public interest portion of this claim. The second issue is the unreasonable interference of this said public right. We believe that spending billions of dollars annually is very unreasonable just to address an opioid crisis. And in particular, the state is not asserting that the opioid drugs do not help the public. We are funneling our vision on the marketing practices. If you look on page 2, 3, and 4, we have undisputed facts that these claims in the marketing tactics that the petitioners are using are actually false. These claims do not properly, adequately inform the doctors and the patients who will be using these drugs on the addictive effects. The state also mentioned, the petitioners also mentioned that they are compliant under FDA standards, but as my co-counsel mentioned, there is a gap within the standards of manufacturing the said drug versus marketing the drugs. We believe that if it comes to the attention to the petitioners that the drugs that they have in question, which might I add, are specifically provided to grant relief for individuals who are vulnerable as they suffer chronic pain. We would think that the petitioners will dial back and address these false claims, but nowhere on the record have they done that, which is why we're here today.
Is there any case where a court has found that the sale or distribution of a lawful product constitutes a public nuisance?
Yes, Your Honor. I would draw your attention to page 23. If we look at the City of Chicago versus Beretta, the court held that if a public nuisance later results from an illegal use of firearms by a third parties, liability in public nuisance is not necessarily precluded simply because the manufacturers no longer control the objects. Essentially, even if the petitioners do follow a legal route in distributing their drugs, there is an issue with the black market. There is an issue with illegally distributed products, opioid products that is plaguing our communities. And in particular, the doctors who are prescribing these drugs, the record shows on page 2 and 3 that the prescription has been reduced. However, we are facing a higher number of addiction, which means that the petitioners are making substantial amount of sales from the illegal market. So in considering that, they cannot just stand on the legality of the compliance and their good faith practices, because we have a tangible issue here where the petitioners are still getting, they're having positive benefits from these illegal trades. And as such, they have control, which brings me down to my third point. The petitioners assert that they do not have control over these drugs, but we disagree with that. We believe that in marketing, in specific, as co-counsel and my co-counsel mentioned, they use third-party journals and third parties to create journals and educational seminars and other educational means that are affecting, especially in the last 20 years, doctors and medical practitioners who are today taking care of the Newport citizens. And also in looking at that control, the major relief that we're looking for, in addition to damages, the second relief is an injunction for them to subside their production. Because if there is this much illegal drugs that are flooding Newport, you would think that it would be very important to take a pause to address the drugs that are out on the market right now. And then, as my co-counsel mentioned, it will take a long time. There will be a long road to recover, but we believe that in getting this injunctive relief, the state will be able to have a little bit of our burden subsided. And secondly, we're seeking damages. We have spent billions of dollars annually. Currently, we're treating 3,200 inmates just on opioid addiction. And these, going back to public right, the citizens of Newport are paying tax dollars. I don't believe that the citizens would want all the tax dollars to go specifically for a crisis that the court can help get us relief from. In looking at people versus Conagra grocery products, which is found on page 22 of the record, the court held that a cause of action is not premised on a defect in a failure or failure to warn, but on affirmative conduct that assisted the creation of a hazardous product. In this particular case, it was a company that made lead, made a product that had lead that affected the general public. And in bringing this case, while it's not a binding statute, I believe that it still shows that the petitioners have an affirmative conduct in how they market their products to the public, especially how they market their products to the medical field of the medical practitioners of Newport. And we're hoping that with these 3 points that I've made today, that we can see that one, we satisfy that there is a public right that is being substantially interfered. And the interference is unreasonable, which means the second prong. And thirdly, we find that the petitioners have control and they're capable of abatement of the activity that's going on. So going back to the Iqbal standard, which is, I believe Your Honor mentioned, is a very, very low standard. If you're looking at preponderance of evidence, you're looking at probably 51%. And if you're looking at the plausibility, it might be maybe 5 to 10. However, the facts that are on the record on page 2 to page 4 are undisputed. We believe that these facts are enough to make a plausible claim for public nuisance. We are currently in a state of emergency, and we believe that this relief will be able to help us dial back, not immediately, but at least try to help subside the 20 years of damages that the state has been burdened with. Thank you, Your Honor. Oh, sorry, may I briefly conclude? And for these reasons, the respondents respectfully ask the court to affirm the 15th Circuit's decision that we have made a plausible claim for a public nuisance.
Thank you, counsel.
Thank you.
Rebuttal?
Yes. Personally. May it please the court. Very quickly, I'd like to make a few points. as my co-counsel and the esteemed justice identified, this case is very like Native Village, and that should be the controlling persuasive case, because there are many producers of these drugs. There are many users of these drugs and many use cases of these drugs. And contrary to what the petitioner contrary to what the state would like you to believe, this is not something we can pretend is constrained to the state of Newport. This is at its core not a geographically bounded issue. It is a national epidemic, and a policy decision is very necessary to address it. Additionally, I'd like to point out that even if the state statute controls, there is no way to argue that two of these elements attach here. There's no way to argue that compliance with regulations and good faith in engagement with the regulations is indecent or offensive to the citizens. And lastly, I want to point out, we target populations who need assistance. We are not exploiting elders and veterans. Elders and veterans are more likely to need our drugs. And for that reason, it's also why we should not, as the respondents say, try for a pause. Try for a pause in helping veterans. Try for a pause in helping elders. That's what the question is, and we should not do that. Last thing I want to say, the respondents want to point to some sort of regulatory gap, which we agree exists. However, they insist that it's a public nuisance answer to that regulatory gap, and we just simply disagree. We have product liability for that reason, and it's also why we don't dispute any of these facts. The facts are undisputed because they're not relevant to public nuisance. Blue is only responsible for making drugs pursuant to their authorization. That's what we're doing, and for that reason, we would like this court to uphold the. Excuse me.
Thank you, counsel. Thank you very much for your arguments, and the case is submitted.
All right, congratulations everyone for finishing your final round. That concludes the argument portion. At this time, I'll have the competitors step outside while our judges complete their ballots. After we have the ballots returned to us, competitors will step back in for feedback, and the live stream will resume. All right, welcome back, everybody. We have concluded our 2022 Blakely-Butler Moot Court competition. I'd like us all to give a round of applause to our wonderful competitors. My name is Chelsea Ogan. I am the competition director this year for this tournament. We are going to begin with feedback from our 4 panel judges, and then we'll announce the winners. So I'm going to turn it over to Chief Justice Jewell. If you'll all, before you start your feedback, just introduce yourself, tell the competitors a little bit about you. Otherwise, you're free to begin.
Okay, first, why don't you sit down? First of all, I want to say congratulations to all of you for making it through a pretty trying weekend of competition. I guess this is your 7th round or so. And that's a lot of pressure. It takes a lot of preparation to be able to argue both sides at a moment's notice. And so that's a credit to all 4 of you. My name is Kevin Jewell. I currently work on the 14th fields in Houston, and for 6 years. And before that, I worked in private practice for about 20 years, doing what you just did, mostly civil appellate work, and it's had some of these issues. So familiar with some of these topics, but I'll just dive right in, and we'll start just giving some feedback as we go through each of the advocates. I guess we'll start with Mr. Materne. Okay. Generally, I thought your presentation was really good. I think that there were times when probably you spoke too quickly, and I think that was common to the whole group in certain parts of your presentation. Just, I know you have a lot to say. You've said a lot of these things probably before in some of your presentations, and I know you feel pressed for time, but it doesn't, if we can't hear it, we can't make sense of what you're saying. Just spinning wheels. So just keep in mind when you do arguments, and particularly when you respond to questions, just be deliberate and pace yourself. And so sometimes you just talk too quickly, and the meat of what you're saying is lost. But all in all, I thought your opening presentation was good. Presented the issue well, the case well. Convincing. Thank you, Judge. Wants to go next? Judge O, we'll just go down the line.
All right, well, my name is Judge Yvonne. I'm a United States Magistrate Judge in the Federal Courthouse in Houston. I'm a 2006 graduate of Law Center. I did not do moot court, but I eventually did end up practicing appellate law after graduation. I was a partner in civil appeals at Bracewell, which is a firm based here in Houston. I'm delighted to be back. Congratulations to all of you. It's been a rigorous competition, and I'm just curious to go around and, which year in law school all of you are.
I'm a 2nd year.
3rd year.
3rd year?
What else?
Goodness.
Okay.
Well, that's very impressive, all, taking time out of everybody's schedule to devote yourselves to something like this. So I guess we're going to take turns talking about this. Okay, so Mr. Materne, I echo what Justice Jewell said. There were times where I feel like you got a little bit flustered, and then you wanted to jump in, and you had a lot on you that you wanted to convey. But I think that sometimes the most effective response to a question is just to take a beat and sort of tee up in your head exactly what it is that you want to say. And so you have a chance to frame it. So you're a little bit, your head isn't getting ahead of your of your speech. So I think that is my general comment, because there were sometimes I found it a little bit difficult to follow, and sometimes as you spoke more quickly, your cadence would also drop, and it also made it a little bit more difficult to hear. So just keep that in mind.
Thank you, Judge. Let me add one thing. I am a 1993 graduate of this law school, and you'd be surprised at how little these rooms have changed.
Have you got a new building yet? I haven't.
But I can't wait to see the new building. So yay for you guys.
I know.
bad at this dungeon. That's Poissant.
Hi, I'm Deborah Poissant, and I'm on the 14th Court of Appeals. My practice was a litigation practice in all areas of the law, and so I tried all types of cases and also in a number of appeals, not nearly as many as my colleagues here. And also we had a firm, which of course not when, and that's interesting. So I had both the solo practice experience and also firm practice experience. And congratulations to all of you, because to go through this number of rounds while you're in law school is really an amazing job that you all did. And we recognize, the stress that you're under with these conditions. So you all did very well. So what I would say is it's great that you stated the correct history of the case and stated your relief right away. That's kind of what we want to hear right away is, the history of the case and what you're seeking. I would say that you emphasize that your argument was going to be based on marketing practices, and probably kind of a recommendation I would make is that the terminology that you used, you said they're going to harp on marketing efforts, and I might use a different terminology than that. And that's just small, really, that's a small thing. And I think that you did a great job, but would echo my colleagues in kind of facing yourself in terms of your arguments. And I thought you also answered the questions well and immediately, and that shows a good knowledge of it.
Thank you, Judge.
Hi, I'm Justice April Farris. I'm on the First Court of Appeals. So we sit in the same courtroom or the same courthouse as the 14th Court of Appeals, but we're our own court. We're number one. So, so I was an appellate practitioner for about 11 years, appellate partner at a law firm. I did a circuit clerkship. So I've done appeals basically my whole career before I joined the bench in 2021. And I just heard that y'all had to go through 7 rounds. And so huge congrats to all of you. That is brutal. I think when I did move courts, we only had a couple of rounds to fill in, and then you had 3 or 4 months before semifinals, and then another 3 or 4 months before finals at the very end of the year. So it was much more relaxed pace. So what y'all done here is pretty incredible. So Adam, I thought you did a great job. And just to jump in with what my colleagues have said, I think there's a difference between trial practice and appellate practice, between moot court and mock trial. And in mock trial, you're very passionate for your cause. The other side is they're bad guys, they're doing bad things. Appellate, it's all about whether the lower court got it right or wrong. And so you can all kind of take a deep breath. You don't have to go so fast. You can just talk about the cases, because appellate courts are terrified of, getting the law wrong. And so you can, kind of fit your facts into other cases to show, why you should win under the law. So when you're getting asked a question in moot court, it's okay to take 2 or 3 seconds and to talk very slowly and just to be like, okay, let's, kind of walk through this methodically and explain why this case is inapposite or why this case controls. So I think it would be helpful. You had some knowledge of cases, and I really liked on rebuttal where you brought this back to the Village case. But I would say for everyone, when you're doing moot courts, it's a good idea to kind of start with a case and be like, okay, this is why this is just like this case, and kind of use that instead of focusing so much on like, we're the company, we're doing this, we're doing that, or the company is bad and they're doing all these bad things. And just kind of focus a little bit more on the law.
Thank you, Judge.
All right, so I could not even hope to pronounce your name. So why don't you tell us your first name?
Mahsa, Your Honor.
Okay. So we'll move on to you. I thought your enthusiasm was great for your position. It was a very persuasive presentation. One thing I thought it was maybe a little too much reading from your notes, and I know that's hard because everyone's really kind of doing that. The more you practice appellate arguments, the less you'll need to do that. There were two issues that stood out to me in your presentation, both when answering questions. The first one was when Judge Ho asked you about the statute, the Newport statute. You didn't seem to answer that question at all. You sounded good at it. So when you answer a question from the court, you really want to try to get it right, and you want to be confident about it. I think you got the confidence part right, and I think that you missed the substance of it. Or if you got it, I must have missed it. But you did well in your tone in responding to the question, I think. And the other issue that stood out to me was when Judge Ho asked you another question about the pleading standard, and you responded that the state had no proof of something in the response. And to me, that's a problem with the substance of what you're talking about here, because if the issue is one on 12b-6, proof has nothing. It's all about the pleadings and whether you stated the claim and you just accept what's stated is true. So you just want to be careful in the future when to know your issue. If your issue is 12b-6, or if your issue is summary judgment, or your issue is what have you, that what the standard is and what you're really focusing.
Yes, right.
And then finally, I think in some of the answers, maybe you were a little too casual in some of the responses, but other than that, I thought it was good.
Thank you.
Well, I think Justice Jewell kind of stole my thunder. No, but I think whenever you have a case, you have to sort of view everything through the lens of a legal standard. So the overarching legal standard, and then you have the individual cases for different principles that you measure against that standard. So you just keep that in mind, whether you're dealing with summary judgment, it's whether the genuine issue of material fact. Here, it's just, even if you take all the allegations as true, is it enough to allow the claim to go forward? So that, just keeping that in mind in any case, whether it's in Newport or real world. I did think that there were times I felt like your answers were a little bit drawn out. I think maybe a little tighter packaging. It's important real estate, because every moment you have up there to persuade the court. I think you obviously had very good command of the case law, which is important. But I agree with Justice Farris' general comment that I like to start with the cases, because that's what the court is going to be looking at. What are we going to look to for guidance? We won't just be writing about policy, but we'll start with, what are the closest analogs under the case law?
Thank you.
Well, as sometimes happens on the 14th Court of Appeals, and the first is just the first because they were there first. But Justice Jewell and I happen to agree with him. Actually, first of all, I really like your confidence, and I think you have very good voice skills. You have a very clear voice, and so it prompts everyone to really listen to you, which is really helpful when you're making an argument. And what I have here circled is that you didn't answer the question by Judge Ho. And 3 times I think she asked you, and she didn't give up, and you didn't give up either. But you finally kind of answered the question. And so sometimes I know when you're presenting argument that, you're trying to think of several things and it's not always clear. And then, some judges think it's good to pause and others not. So it's really hard to make that call. But it is important that you answer the question that the judge asks. And so I also circled, it's great that you didn't give up, right? And you didn't get flustered, because that could happen. So those are really my only comments. Thank you. Because yes, Judge Jewell also stole my thunder.
I enjoyed your presentation. I thought you had a good response on I'm gonna mispronounce it. That topic. But I thought you had pretty good end of the case law. And yes, slowing down would help a lot, because that was one thing that was very hard. I'd be trying to write and it would already be like 2 or 3 points down the line. So slow down for us old folks. So
Old folks.
Thank you.
wait a minute.
tell you, one story is quickly on the lines of answering the question. One of my very first arguments I gave in this circuit. Right out of the box, I was asked this very long hypothetical question. And I was a very young lawyer and I was really pretty nervous because it's first or second time up there. And even though I was representing the appellee, I didn't really have the burden to show the case was reversible. I really had no clue what the judge was saying. And it's just Chief Judge of Police all the time. So he's got this Cajun boy accent. I just wanted to laugh because he would just carry on. And I had no idea what he said. And he talked for 5 minutes. And so when he finally stopped and looked at me, I just said, yes. And that was really nice. So sometimes this is what you have to do. So, all right, so we'll move over here. You want to go first this time? You start.
Sure, Mr. Okolo, is that, did I pronounce your name correctly? You have a really nice demeanor at the podium. I appreciate that you seem very welcoming of questions, good pacing. You did start to speak more quickly as you went along. I know there's the clock is sometimes can feel like your enemy because you've got a lot that you want to cover, but don't let that change your cadence. There were times I felt like you were doing more reading from your notes, and part of it is just practice and comfort. Notes, I never went up there without notes as a security blanket, but you also want to, make sure that you're just speaking directly to the court, because, listening to someone read is not as persuasive as having a dialogue with the court when you're in the lecture. There were a couple of times. Oh, I know, when you were addressing the political question doctrine, you were talking about the Baker factors. Courts, you can assume some level of knowledge, but I think it's much easier to follow if you say under the first Baker factor, which says X, and then sort of use that as your hook to sort of discuss and analyze, how you view the applicability of the Baker factor. Because I was having to think about it. I've dealt with Baker many times. I'm like, first factor, second factor. First factor is textual commitment. Are we talking about, manageable standards? Are we talking about some other factor? So I'm distracted in my own head because you didn't signpost that for me. So it's sort of a small technical detail, but I think generally when you're talking about legal issues, you want to start with a legal principle first and then talk about how you think that applies to your client's case.
To that, I would just add a couple additional comments. Did you have a prepared speech or outline or something? Because it looked like you were reading off of something that you had.
I had a speech,
Right.
And it's changed over time because sometimes I'll get a question and it messed up the timing because I'm like, I still haven't covered everything.
Right.
So I kind of, it's like, talk about this, dot, talk about this.
Right, you want to be careful going into an oral argument with a prepared speech. You want to think about it as though the topics are on index cards. Y'all probably don't even know what index cards are, but you just cabin the different points. And so when they come up in the questioning, you have a response for 1, 2, 3.
They're like
So-
the hard copy version of like those things you see in Quizlet.
I guess my question would be, would it be appropriate to understand like this form as more of a dialogue rather than like a monologue?
It is if the court's asking questions, but you want it to be a dialogue because you want to know what the court's concerned about. And the court is largely going to ask you questions about the issues that are weakest to you. And so you want to know what that is. You can tell that's your point. So, sometimes you'll do an argument, you won't get a lot of questions, but today you did. And so you have to just be prepared to be nimble in your presentation. One thing I would say, I thought you had a good tone in your presentation, but I would watch your eye contact because several times you were looking up at the ceiling and I was like, is it raining? And so just be careful about that because you want to stay focused on the board. And at one time in your presentation, you used the word stuff. So try to avoid those types of Next time.
I should be a little more specific.
Well, just be more professional, so word stuff and the very casual conversation. You want it to be a conversation, but you don't want it to be too casual, like you're sitting in a bar. So just be professional and use the right terminology.
Actually, I'll start with that little comment, because I wrote it down, respond to some of the stuff said by opposing counsel. So what you might want to use is respond to opposing counsel's points regarding something like that, that's a little more specific. I thought that you had actually your language in regard to how you presented your argument was very good. Your introduction said the court remains an avenue for relief. Boom, set it out right there. You know, this is our main point. Court remains an avenue for relief. I thought that was very good. You've also said that the marketing practices are at the heart of the lawsuit. And the claims are specific. And so you also had, our theory is this, and then you set it out. And so, I would have the same comments as my colleagues about reading, but I thought really what you had set out, and the way you set it out was really very good and very specific. You answered the question regarding the use of products liability versus nuisance law. And I think that your answer was good as to that. And then you stated the relief requested and said that you detailed how you could discover and calculate damages, which was kind of central to the argument of, how is this discoverable and how can we calculate these damages? And you had a way to do that. So that was very specific and very good. So those were generally my comments. I have the same kind of comments about your demeanor. You have a good demeanor up there. I'm someone that later in my career somehow started rolling my eyes, and so I stopped reporting some depositions where I knew I would find the witness not plausible. Okay, and so you do have to be careful with facial expressions. That's all the comments.
I don't have much to add. You had great energy. I really liked how you gave a good analogy about wearing down the filter. I like that. I thought that was very helpful for me to kind of understand what your theory of the case was. So I thought that was great. In terms of staying away from speech, the way that I always like to prep for oral argument when I was doing it was I would have a very short outline. I'd have my introduction. And then I have, just a little bit of material to really time me over until I could get into a discussion with the court. And then I would have like 3 or 4 bullet points that I would call my must-hit points. Like, these are the 4 things, if the court talks my ear off the entire time, these are the 4 points that I'm gonna jump to, when the court is catching their breath. I'm gonna, try to get these 4 things before I sit down. But really, that's all that you need. Because the court, what you really want to spend your time on is answering the court's questions, because they probably know the weaknesses of your case and maybe they want to rule for you. And so your job is really to put their minds at ease about these big concerns that the court may have. So when you're prepping, I would just suggest don't focus so much on, I'm going to try to give the court all of this material, but focus on, okay, here's just a few points I want to hit, and then spend the rest of your time kind of getting ready to answer the tough questions.
Let me just add one thing, and this is both to both of you, because you were representing respondent here. Respondent's argument, it is responsive to what the petitioner's presentation. Of course, there's always, in real life too, there's always some uncertainty about exactly what you're going to hear from the other side. I find it most effective if you can weave in your rejoinders to their argument in your affirmative presentation, rather than waiting until the end to say, and let me address some things that they said. Because if you prepare both sides of the argument, you'll know the pros and cons of each of the issues. And so you can just say, present it sort of like the petitioner has argued X, but the case law says Y. I'm just simplifying that, but just to weave it into the context of your argument rather than saving it to address it again.
And I just wanted to say that what I used to do all of the time is I would really practice in front of the mirror. And now, you know, with iPhones, you can just record yourself because you never see yourself when you're presenting. And it was a real shocker for me the first few times I did that, you know, to see, oh, I have this expression or that expression, and it helps a lot. Because then you have kind of a contained awareness of how you present.
Thank you. Would you like to start last round?
Yes. I thought you did a great job with signposting. I really appreciated how you used page numbers from the record and worked in references to different cases. I thought that was very helpful. One thing I wrote down was slow down. Fast. It was kind of hard for me to keep up. And then the only other comment I would say, and this is just I had to practice this because I did the exact same thing, and you know, it took me probably 4 or 5 arguments before I kind of trained myself out of it. But instead of saying we believe this or our position is this or we think this, just say, you know, we believe the car is red, just car is red. So that's just something that takes practice, but I think that
You have an excellent demeanor. You look like you want to be there. You know, and that's there's no substitute for that. When you want to present your argument, when you all have great confidence, you know, and I would say you're just in that way, that's really your presence there just immediately was, I want to be there and I want to present this argument. And believing in your cause is always the best presentation. So first of all, that was to me very noticeable. And then you present a question. Does the state fail to state a plausible claim for nuisance? And you just put it out there, you know, as your colleague did. And I think that that's really great to do. You set up the standard. On one of the questions, you seem to answer the question, and you kind of conceded the point. And so what's really important in argument is that, you know, if there's something that doesn't work in your favor, to admit it, because we know it, you know, and we you know, sometimes lawyers don't think maybe the judges know it, or, you know, but we do know. And so that's a really good thing to do, is to say, well, you know, yes, but you knew the case authority in response to Judge Poe's question. And you kind of had a really good immediate response to that. All of the record references by everyone were excellent because you seem to know the record. Then you spoke about the injunction, and you had a good summary of why the injunction was necessary. And I thought you did a great job with that too. And you know, it's good that at the end, if you think that you need to give a conclusion, that you respectfully request support for that, and you did that.
Ms. Harry, is that right? Yeah, I agree with all that. One thing I thought was probably the best about your presentation, I think you were trying to do what Judge Hodel referred to in the sense of working into a rejoinder some of your main points you wanted to hit on, because when you stood up there, you started addressing the points that the other side had raised. And then you worked into your presentation in response to my question about Iqbal being a low bar and the possibility standard and so forth. And so that was really good that you were able to just weave all that in. And so that was a good approach. I thought your answer to Judge Ho's question was real good. I forgot what the question was.
I never either.
I wrote down good answer to Judge Ho's question. Enthusiasm was good. You did have trouble in answering one of the questions. I think it was Justice Farris about whether this was an unworkably broad problem that we're having. And so you did stumble there, but overall I thought it was a good presentation.
That was actually my only additional comment, was just that one issue, you know, I think part of it is just having the case law cataloged up here so you can revert to the case. But I think you exude confidence in the program. And I think Justice Poissant is right. It's like you want to be there, you're welcoming in questions. Really enjoy your presentation.
but also slow down.
Yes, yes, for everybody.
Thank you.
Well done, everyone. So, ready?
All right, that concludes our feedback portion. I'm gonna quickly say a couple of words, and that is that I'm so proud of each and every one of our competitors for doing this. I know how hard it is to get up here and put yourself out there and be at the mercy of judge questions and having to think on your feet. So I'm very proud of you all. And I'm very thankful for our judges. I cannot think of a better panel to judge an appellate competition. Every single one of these attorneys, justices, federal judges, they do this as a career. They've done this for their whole careers, either in private practice or in the courthouse. So I hope that you all took these comments to heart, because this is an incredible opportunity to hear from them. I'm going to get to our results now. I know that's what everyone's waiting for. I'm going to start with best speaker. And drum roll, please. Our best speaker for the 2022 Blakely-Butler competition is Deborah Billy Gillis Harry. Congratulations. Thank you. We'll get pictures afterwards. And then now for our champions of the 2022 Blakely-Butler Moot Court, it is Respondent Team 9, Geoffrey Okolo and Deborah Billy Gillis Harry. Congratulations. All right, we are going to close the live stream and take a couple pictures, but otherwise that concludes our 2020 competition. Thank you, competitors. Congratulations again.
Congratulations.